Hi everyone, my name is Chris Morehead. I'm an associate in the Labor and Employment Department at Tonkin Torp. Welcome to the latest installment of our Coffee Break webinar, Enforcing Pandemic Workplace Policies. We've designed our Coffee Break webinars to provide you with a practical advice for your business to thrive during this pandemic. Next week, you'll be hearing from Megan Ruther to discuss how to handle a COVID-19 diagnosis in the workplace. Let me pause and make a note about this format. First, please know we are recording this webinar. You do not need to sign a disclosure and no private information of yours will be shared. Please know, however, that should you choose to participate in our Q&A section, your question may be recorded in association with your name. We've designed this webinar to include questions about workplace safety rules that we've received over the past few months, so hopefully I've anticipated and will answer many of your questions. If not, feel free to submit questions in the Q&A section of your Zoom app. After the presentation, I will conclude with a Q&A session and will try to hit as many of the questions as I can. Because the situation is rapidly changing, I may not know the answer, or your question may be too nuanced or specific for me to address in this webinar format, and I welcome you to reach out to me or the Tonkin Torp attorney you usually work with. Also, I welcome any feedback you may have after this webinar. If there are topics you want to hear about, tell us. We hope to be a source of information for our business community throughout this challenging time. Finally, please note that information presented here is not intended to be legal advice. So with that, let's get to the program. The focus of today's presentation will be on the new reality that employers are facing with respect to ensuring that they maintain a safe and healthy workplace, and specifically best practices for how to enforce those rules in a fair and consistent manner while avoiding potential legal pitfalls along the way. I'll assume that many of those in attendance today already have a solid understanding of many of the safety requirements and recommendations I'll be discussing. I'll also assume that a number of you have gone through the process of creating and enforcing general workplace rules during the normal course, so I'll not be going over those issues in great depth. Rather, I'll provide a high-level summary of information regarding the relevant laws and executive orders that employers should consider when making and enforcing the workplace rules, and then move on to some of the trickier situations that might arise out of enforcing these workplace rules. Our goal with this webinar is to help you understand the legal obligations employers have to enforce health and safety rules, what may happen if your company is found non-compliant or not enforcing the rules, the steps you can take to enforce the rules in an equitable but defensible manner, and some of the potential liabilities you should think about when you enforce the safety rules. Let's get started by reviewing some background of what OSHA has to say about the susceptibility of transmission of COVID-19 at the workplace. As we've all seen in the news, community spread of COVID-19 has been associated with workplace outbreaks both locally and nationally. For example, we've seen reports of COVID-19 spreading rapidly at meatpacking facilities, seafood processing plants, and nursing homes. In fact, as you can see on the slide, OSHA has developed an occupational risk pyramid employers may use to rate the risk of exposure to COVID-19 based on the employer's industry or workplace setting. At the top, we have very high risk exposure, which according to OSHA includes healthcare workers who perform specific medical, postmortem, or laboratory procedures on COVID-19 patients. Next, we have high risk, which includes workers that have high potential for exposure to known or suspected source of COVID-19, such as those who perform healthcare delivery, support, and/or transportation services. The medium risk band includes those who have contact with the general public, such as people who work in schools, high population density work environments, high volume retail settings, and those who travel to locations with widespread widespread COVID-19 transmission. So this ban may apply to employers with employees that have at least some regular engagement with customers, vendors, or members of the general public. And then the lower risk band of those who have jobs that do not require contact with people or the general public. So this may include folks that work remotely or have very limited interaction with people in an office setting. Depending on the applicable risk band, OSHA recommends varying degrees of safety measures that employers should implement. These safety measures include specific types of engineering controls, administrative controls, safe work practices, and PPE recommendations. While we don't have time to go over all the specific recommendations for each of the 4 risk bands today, we'll go over some of the more common safety practices shortly that are commonly seen in medium and lower risk categories. Please also feel free to reach out after the program if you have specific questions about how OSHA's safety recommendations may be applied to your workforce. In any event, the bottom line is that there should be no doubt that employers, no matter where they fall in OSHA's risk band, are on notice that they should implement appropriate safety measures and enforce them to mitigate the risk of exposing employees to COVID-19 at work. So let's take a quick look at the authorities governing rules and why it's so important for employers, why it's so important for employers to take these new COVID safety precautions seriously and what some of the potential liabilities are for noncompliance. Under Section 5A1 of the Occupational Safety and Health Act, also known as the General Duty Clause, an employer has the obligation to protect workers from serious and recognized workplace hazards, even when there is no standard for doing so. Employers must take whatever abatement actions are feasible to eliminate these hazards. COVID-19, of course, has been recognized as a workplace hazard falling within the General Duty Clause. But unlike many other recognized workplace hazards, OSHA has not yet released any specific rules for workplaces that must be followed. To date, they've just released a list of recommendations. That doesn't mean additional rules aren't forthcoming. In fact, Oregon OSHA recently announced that it has started working on temporary rules to address the coronavirus. The rules are expected to be released on or around September 1st and may remain in effect through at least February 2021, so stay tuned for that. This follows on the heels of Virginia, which earlier this month was the first state to adopt a regulatory mandate requiring employers to determine the exposure risk level, again from low to very high, and tailor their COVID-19 protections based on the exposure risk. I think it's not unreasonable to expect a similar framework once Oregon OSHA releases its temporary rules in a few weeks. In any event, we already know that Oregon OSHA has been investigating workplaces following receipts of complaints for non-compliance with Governor Brown's executive orders regarding social distancing and PPE requirements, such as the indoor face mask covering mandate in businesses open to the general public. In fact, since early March, there have been about 6,000 complaints filed against businesses for allegedly not following Governor Brown's orders. Employers may be cited thousands of dollars if Oregon OSHA determines that an employer is non-compliant for the first offense. But those fines and penalties may increase to tens or even hundreds of thousands of dollars depending on the employer's violation history and the severity of the offense. In some severe cases, OSHA may also shut down a place of business until it determines the workplace is in compliance, which can obviously be extremely costly. Further, violation of Governor Brown's executive orders is punishable as a Class C misdemeanor, which carries the possibility of fines and is punishable by up to 30 days in jail. As the number of infections continue to rise in Oregon and across the country, I think we can expect Oregon OSHA to get stricter and potentially heavier-handed with its enforcement measures. In addition to administrative fines and penalties from OSHA, there's also the potential for employees to file workers' compensation claims if they contract COVID-19 on the job. While it's generally the employee's burden to prove they contracted an injury or illness at work, lobby groups in Oregon and other states across the country are drumming up support for legislation which would create a rebuttable presumption that employees who work in certain industry and who catch the disease did in fact contract COVID-19 at work. Generally speaking, such a determination would cover any time loss and medical expenses related to the employee being treated for or recovering from the disease. But even in the absence of such legislation, employees may attempt to argue that they caught the coronavirus at work because their employer did not implement or otherwise sufficient rules. For example, an employee may learn that a colleague had coronavirus, and then a week later they too catch the disease. But it might still be an uphill battle for the employee to prove they caught it from that particular coworker. Evidence that the employer was lackadaisical about enforcing workplace rules might help them win their claim, which of course may negatively impact the employer's workers' compensation premiums, or alternatively put them on OSHA's radar if OSHA catches wind of allegations of non-enforcement of the safety rules. Lastly, I think there's also the potential for tort claims such as negligence to be filed against employers that don't enforce their COVID-19 safety rules and policies. Now, it's generally difficult for employees to sue their employer for a workplace injury in a civil lawsuit because so long as the employer has workers' compensation coverage, the employer is entitled to a defense called the workers' compensation exclusivity defense, which essentially means that the employee's only remedy for their alleged injury is in the workers' compensation forum. Still, that doesn't necessarily stop employees from trying to sue their employer under a negligence theory. For example, just last week, a Portland-based trade worker sued both his employer and the employer's very well-known Seattle-based client for $950,000. The employee alleged that the employer and its client were negligent in enforcing COVID rules at the employee's job site, which was owned and operated by the employer's client, which allegedly caused the employee to contract coronavirus and spread it to his family. While we don't know what the outcome of that case will be, the cost of defending litigation alone will likely be substantial, and I don't think it's unreasonable to expect similar claims to arise in the future. So from a risk management perspective, it is imperative for employers to try to mitigate the risk of COVID-related claims by implementing and enforcing the appropriate workplace safety rules and policies. So with that, let's take a look at some of the common COVID-19 safety rules that employers should be thinking about when trying to keep the workplace safe in order to mitigate the risk of legal claims. I assume that many of you are likely already generally familiar with many of the safety rules that businesses have started implementing at the workplace pursuant to executive orders and guidelines set forth by the Oregon Health Authority. If not, the OHA has a list of requirements and recommendations for specific industry sectors, including retail establishments, personal services providers, bars, restaurants, shopping centers, fitness organizations, and recreation facilities and organizations. You can find the sector-specific guidance relevant to your business at the OHA website, which includes specific requirements and recommendations your business should follow. In addition, the OHA, OSHA, and CDC all have generalized lists of various types of workplace safeguards that employers should at least consider for their workplace. For example, employers should consider implementing physical distancing measures between employees. This may include making modifications to the physical work site, such as floor markings or installing plexiglass shields. Employers should also restrict use of any shared equipment and require disinfection between use. Employers should reinforce that meticulous hand hygiene is of utmost importance for all employees and should consider purchasing and installing hand sanitizer stations around the workplace. Employers should also make rules limiting the number of employees gathering in shared spaces such as conference rooms and break rooms, as well as restricting or eliminating non-essential in-person meetings. Of course, employers should also require employees to work from home to the extent they are able to perform their jobs remotely. If employees are coming into work, another recommended policy is to require employees to certify they are not feeling symptoms of COVID-19 and that in the prior 14 days they have not been in contact with anyone who has symptoms or has been diagnosed with COVID-19. Employers may also consider adopting a policy requiring employees to sign in and sign out at work such that if an employee gets infected, the employer may contact trace everyone else who was at work during the same time as the infected employee and quarantine coworkers as appropriate. Further, employees who have traveled to areas with high rates of infection may be appropriately instructed to self-quarantine and be symptom-free for at least 2 weeks before they may return to work. Lastly, and likely the most common requirement that has also garnered the most press across the country is the face covering mandate. As most of you are likely aware by now, Governor Brown mandated that businesses that are open to the public must require all employees and contractors to wear a mask, face shield, or face covering unless the employee or contractor is in a location where they are not interacting with the public and can maintain at least 6 feet of distance between other people. In addition, the mask mandate also requires employers to provide employees or contractors with face masks, face shields, or face coverings, and also put clear signs about the mask mandate around the workplace. In any case, even if the mask mandate doesn't apply to your workplace, recommendations from OSHA, CDC, and the OHA all make clear that the risk of transmission of COVID-19 at the workplace is greatly decreased if employees are required to wear the mask at work, so it's a good idea to require it regardless. So with that, let's go over our list of some of the best practices for how to enforce these COVID-related safety rules. Before going over the list on this slide, I want to note that this list is in no way required or necessarily comprehensive. Rather, in my experience, it is a reliable method for informing employees what the company's expectations are, why those expectations exist, and what the consequences are for not following the company's legitimate expectations. The goal is to let employees know the rules of the road so that if the rules are violated, the company is in a good position to defend against legal claims down the road if the employee is disciplined and or fired. So let's start with the first point. Have a clear policy laying out the company's expectations. Just as with all other workplace safety rules, employers should clearly communicate COVID-19 workplace safety rules and procedures to their workforce. When implementing new policies, employers should remind employees that the rules are designed to protect everyone in the workplace as well as their families, and that employees will be updated when or if the policies change. The policies should include the specific safety rules that the employees are expected to follow, regardless of whether those rules are required by law, because, as a reminder, employers can require additional safety restrictions beyond the baseline of what the law requires. Second, communicate the policy and recirculate it as necessary. Everyone should understand that the new workplace policies that the company has implemented so that no one can claim any surprises about what was expected of them when they return to work. It may also be a good idea to require employees to sign an acknowledgement that they have received and reviewed the COVID-related safety policies and agreed to abide by their terms. Also, recirculate the policy when appropriate. For example, recirculate the policy anytime the policy is updated, or alternatively, when there's been instances of noncompliance and you need to remind employees of the company's expectations. Third, update the policy and the company's expectations based on new relevant guidance. I think we can all appreciate that the amount of information about COVID-19 can at times feel overwhelming and difficult to keep track of. That said, CDC, OSHA, and the OHA do release updates and recommended practices as these agencies learn more about the disease, which may help you implement additional best practices in the future. It's important to make sure that your policies aren't stale, especially if your policies become an issue in a regulatory investigation or a lawsuit, so make sure to update the policies based on recent guidance from the relevant authorities. Fourth, clearly state the consequences for noncompliance. Employees should be on notice that failing to abide by workplace safety policies may subject them to discipline up to and including termination. If you have a policy acknowledgement, that's also a good place to have employees acknowledge that they are subject to discipline if they don't follow the safety rules. A common question we get is, what should the consequences be for a single rule violation? I think that depends on the employer. Maybe the employer already has as an existing progressive discipline policy where it might make sense that violating safety rules will place the employee on the next step of the progressive discipline track. Alternatively, the employer may adopt a separate progressive discipline track just for safety rule violations. Or maybe employers will reserve the right to discipline on a case-by-case basis, depending on the severity of the violations. Whatever it is, think about what makes sense for your workplace culture, but also make sure that it isn't toothless such that there are no meaningful consequences for serial violators. Fifth, select and identify a point person that can field employee questions or concerns about the policy. It's understandable that employees may have questions about protocol or procedure related to new safety rules. If employees do have questions, it's helpful to have a point person that can field those questions so that the employer's response regarding its position on expectations is consistent. You don't want a case of employees getting mixed messages. In other words, if a lawsuit does arise out of discipline related to enforcement of workplace rules, you don't want an employee claiming that they received information contrary to company policy from a supervisor who was speaking off the cuff. To that end, managers and supervisors should also be encouraged to direct questions or concerns about company policy to a point person. Sixth, be prepared for situations where employees object to the rules or challenge their necessity. Such employees should be reminded that the company is required by law to maintain a safe workplace, and the company is doing its best to keep everyone safe. Employees may also be informed that the company's failure to implement and enforce these rules could place the company in legal jeopardy. These reminders, in our experience, can sometimes help employees understand that the company isn't creating rules to inconvenience them, but rather because the company is obliged to do so. Educating these employees at the front end may prevent them from violating the rules down the road if they think the rules are an unnecessary burden. Seventh, enforce the policy equally and consistently. This is probably one of the most important steps to avoid employment claims on the back end. So for example, if someone is disciplined for refusing to wear a mask, be sure that you've utilized that same type of discipline in prior situations where an employee refused to wear a mask, and be prepared to commit to that same type of discipline in future cases. The point here is to avoid discrimination claims by an employee alleging they were disciplined for some other protected feature, and the refusal to wear a mask was pretext for the discipline being issued. If the employee can point to a coworker who wasn't disciplined under substantially similar circumstances, their claim may become more colorable. That's why best practice is to check for what employment lawyers call comparators. In other words, identify if there are other employees that committed the same offense but were not disciplined as harshly. If there are such employees, make sure that there are legitimate and verifiable reasons for why this violation is being treated differently, and be prepared to defend it in the event the employee alleges discrimination down the road. Lastly, document the enforcement decisions, and do it contemporaneously or at the very least shortly after the incident. This is the best practice for any type of disciplinary event, and violation of new safety rules shouldn't be any different. Even if it is a verbal warning, document the conversation with something as simple as an email, which has the great feature of being date and time stamped and creates a nice record of when discipline is meted out. This sort of documentation makes it very difficult for plaintiff employees to claim those disciplinary events never happened, and makes for powerful evidence for employers to use when defending employment lawsuits. So let's segue to some of the potential pitfalls that employers might face along the way while enforcing new COVID-19 safety rules and procedures. The first two involve objections to wearing face coverings or face masks in the workplace. For example, employees may claim that they cannot wear a face covering due to some medical condition or other disability that prevents them from being able For example, employees may claim that they cannot wear a face covering due to some medical condition or other disability that prevents them from being able to safely wear a face covering, or that their religious beliefs do not allow them to wear a face covering. This can obviously create some tension with employer rules and state mandates requiring face coverings in the workplace. Under the Americans with Disabilities Act and Oregon law, employers generally have an obligation to provide reasonable accommodations to an employee's job duties, rules, or requirements unless doing so would present an undue hardship. The key inquiry employers have to think about in the context of COVID is whether a reasonable accommodation exists and that would allow the employee may have an exception to the safety rules. Importantly, before an employer determines that no accommodation exists, the employer must engage the employee in an informal dialogue about the potential accommodations, which is also known as the interactive process. Failure to engage in any interactive process and simply denying the employee's request as unreasonable is, on its face, likely a technical violation of the ADA, which could get you sued. It's important to note that if an employee claims they need an exemption from the face covering rule due to their disability, the employer is entitled to request medical verification from their healthcare provider that complying with the face covering rule is either unsafe or unhealthy. When requesting medical verification, it is permissible to give the employee a form and cover letter to present to the employee's medical provider to get a better understanding of the employee's claimed disability and request that the employee return the completed form within a reasonable period. Similarly, under Title VII of the Civil Rights Act and Oregon law, employers must accommodate an employee's sincerely held religious beliefs or practices unless, again, the accommodation would impose an undue hardship on the employer. If the employee claims their religious beliefs prevent them from complying with face covering requirements, employers may request doctrinal verification of the employee's sincerely held religious belief. Once an employee has submitted medical or doctrinal verification supporting their exemption from complying with face covering rules, the next step is for the employer to explore possible accommodations and whether an undue hardship exists. Please note that determining whether a reasonable accommodation or an undue hardship exists is always highly fact-intensive, meaning usually there aren't black and white answers. That said, in the context of COVID-19, potential reasonable accommodations might include providing an alternative form of face covering, such as a face shield, allowing the employee to perform their job duties in an isolated or socially distanced area, or alternatively, potentially allowing some modification to their job duties that don't require them to interact with the public or other employees. If you are facing a request for accommodation, I think it's always a good idea to consult with your Tonkin employment lawyer before denying such a request. Another potential pitfall employers may face are whistleblower retaliation claims. An employee can generally allege a whistleblower retaliation claim if they have reported activity or conduct that they believe to be unlawful, they were subjected to some adverse employment action, excuse me, and there's a causal connection between those two things. In the context of COVID-19, it is not unreasonable to expect that some employees might be particularly concerned about coworkers whom they observe not following the safety rules to a T. Those concerned employees may start reporting other employees who are not following the rules to human resources, their managers, or even OSHA or BOLI. And if an employee is reporting, for example, something as simple as other employees not wearing a face covering in violation of Governor Brown's executive orders, that might be sufficient for the employee under Oregon case law to have reported conduct they believe to be unlawful. At risk of stating the obvious, employers shouldn't discipline employees for making these types of reports. In any event, in our line of work, we've seen all sorts of conduct claimed as adverse action for engaging in so-called whistleblowing activities, including perceived unwarranted or low performance reviews, low raises or bonuses, and even complaints about ostracism, which came weeks, months, or even years after the so-called protected activity. This is just another good reminder that employers should be extra careful when meting out discipline against employees who have made reports or concerns about rule violations or employees they observe violating rules, and make sure that any forthcoming discipline or other adverse action against the employee is well documented and defensible. Related to whistleblower claims, an employee who has raised concerns about workplace safety issues and is subsequently disciplined and or terminated may also try to allege a common law wrongful discharge claim as an alternative theory of relief. Although the remedies are generally the same as whistleblower retaliation, the wrongful discharge theory might be used to encompass a greater array of activity by the employee. For example, an employee may not have reported something as is required by a whistleblower retaliation claim. Instead, they may claim that they were fired because they refused to do something, such as going to work or performing other tasks they deemed to be unsafe or non-compliant with recommended safety practices. This is an issue we expect to see litigated in the courts over the next couple of years at a minimum. Lastly, there's discrimination lawsuits, which I already touched on previously. Again, the big takeaway is that employers should be enforcing COVID-19 safety rules equally and consistently so as to avoid an employee claiming that they were singled out for more severe discipline than someone who committed the same rule violation due to some protected characteristics such as sex, race, age, disability, etc. For these reasons, it might make sense, to the extent possible, to run discipline decisions through the same manager or HR employee to make sure that the employer has someone tracking how these employees are being disciplined for safety rule violations and can quickly identify potential disparities in how the rules are being enforced. This can go a long way to cut off potential discrimination claims in the long run and ultimately prevent your company from getting sued. So with that, I'll conclude today's presentation, and I see that there are already some questions in the Q&A section, and if anyone has any other questions, please feel free to submit them now. Okay, so the first question is, does Governor Brown's mask mandate require customers, patrons to wear face masks in the business? Yes and no. It depends on whether first of all, it depends on whether the business is open to the general public. If it is such an entity, and Governor Brown has provided a list of businesses, types of businesses that fall within the definition of business under the most recent mandate. So provided that the company is such a business, then yes, the customers and patrons are required to wear masks in the business, subject, again, of course, though, to potential accommodations that the customer or patron might have under the American with Disabilities Act, in which case that doesn't necessarily mean that the employer is required to allow that customer or patron to come in, but instead the employer or business is encouraged to engage in a discussion as to what sorts of accommodations might be available to that customer or patron. And there's also a whole other host of potential accommodations that the business may make available to customers, and I'm happy to go over that detailed list offline. Okay, another question. If an employee has tested negative for COVID, can they return to work as soon as they get the results of the test, or do they still have to wait 14 days? So this is still an area that's not entirely clear. Recently, the CDC has recommended that if the employer is following the so-called testing method based on test results, there's still generally a waiting period. The last time I looked at it, I believe it was 72 hours that the employer should wait before 72 hours between the time the employee tested negative and there's been an offset of symptoms for a period of at least 72 hours. But admittedly, I have not checked on that specific requirement recently, but I'd be happy to follow up with you after the program. Okay, well, with that, I guess I'll conclude this presentation, and thank you all for joining. And again, if you have any specific questions about enforcing workplace rules in your business, please don't hesitate to reach out by contacting me or other talking attorney you usually work with.